Welcome everyone to today's Buy Sell Chat webcast. We have a very special guest with us, Lea Bailes, who is a partner at Creative Planning, and he does estate. He's a estate planning attorney, working directly with his clients to create and maintain a customized estate plan to assist in protecting their estates and beneficiaries from probate, taxes, and creditors. With nearly 2 decades of experience in the legal services industry, Lea offers his clients a comprehensive estate planning experience. And prior to joining Creative Planning, Lea actually was a solo estate planning practitioner as well. Received his bachelor's of business administration from Baylor University, and then did his JD from Baylor Law School. Outside of work, loves being outdoors as much as possible with his wife, 2 kids, and 2 dogs. So as a dog lover, welcome, Lea. We're definitely excited to have you on.
Yeah. Thanks, Timber. I appreciate it.
Yeah. So today, for everyone on the call, we're excited to dive into sort of 4 key aspects to help understand and simplify the estate planning process for our investors and listeners. It's what is estate planning and why is it important, especially for real estate investors? How can estate planning minimize taxes for investors? What are sort of the necessary steps to create an effective estate plan? And especially, what's the first step? And what are the common mistakes to avoid in real estate planning? And, just as an investor, and would love to kind of hear your thoughts out on that. So with that, Lea, could you just share with our listeners who you are and what you do as well?
Yeah. So thanks, Denver. So my name is Lea Bailes. Like Denver said, I'm an attorney with Creative Planning. We're based out of Overland Park, Kansas, but we do work all across the country. And I'm an attorney licensed in Missouri, Kansas, and in Texas. And so I do help clients create estate plans from what we'll talk about, like core estate planning, wills and revocable trusts, and incapacity planning, like using powers or creating powers of attorney, to more advanced planning, where we're looking at ways to maybe transfer assets to like to your kids or other beneficiaries during lifetime. Also, ways to maximize basically what you have for an estate tax exemption right now, which we just have right now a historically high estate tax exemption. So working with clients on ways to take advantage of that to pass as much as possible tax-free to beneficiaries. And so, yeah, a whole broad spectrum of estate planning. So yeah, strategies that we use for clients, and also look some at asset protection, what we can do for asset protection in places where it makes sense, and situations where it makes sense. And I should just say that everything we'll talk about today is very general. And so, as with any estate planning, it is very specific to your particular situation. So, like, these are all going to be very broad topics we talk about, and would highly recommend speaking with somebody about your individual situation. But hopefully, this will give you some, like, at least a foundational level of understanding on where to start or where to go for your next step, or wherever you are in that process. So, yeah, thanks for having me on today, Denver.
Yeah, for sure. And I highly encourage everyone to actually talk to Lea about this because he's done it for over 20 years. And you learn a little bit about his experience, and then, he'll share stories and whatnot about all of these aspects. And so, for the benefit of everyone on the call, love to start at the basics. What is estate planning?
Mm-hmm.
Why is it important,
Mm-hmm.
especially from a real estate investor standpoint?
Sure. Yeah, I look at estate planning really in 3 main areas. So one is really just your core estate planning. So this is what happens to your estate when you pass away. So there's really 3 ways to handle that. So one way is to just do nothing. And then you let state law, whatever state you're in, control what happens to your estate. It might not be what you want to have happen. So without planning, there is still a plan in place for you. It's just based on code, based on the statutes of that state. So, and then you run into situations where you might have property as real estate investors in multiple states, and that becomes somewhat of a mess. So that's one option, right? Is just to not plan at all. Another option is to just have in place, basic estate planning documents like a will and powers of attorney, and then let distribution of your estate occur through a probate process. So probate is basically a court process where you have an executor or personal representative, depending on which state you're in. They're the same thing, just called different titles, where they are responsible for working with a court to distribute your estate to your beneficiaries according to the terms of a will. And so some states, like Texas, for example, we have an independent probate process that is, in theory, a little bit simpler than other states. There's no statutory, like a percentage of your estate that's owed for costs associated with executing that estate through probate, but that can incur a lot of attorney's fees. And then also, if you have property in multiple states, you end up maybe opening probate up in your primary state like Texas, and then having to open up ancillary probate in other states where you own property. So that's an option. It's not necessarily the ideal option, but then what we typically recommend to nearly all of our clients is that they at least have in place what's called a revocable living trust. And that is what I recommend, again, nearly all the time to clients that have real estate investments. A revocable living trust is it's like a will, in that it's going to outline the distribution of the estate, what you want to have happen if you were to pass away. But unlike a will, we can actually title assets in the name of the trust, or list the trust as a beneficiary of other assets, depending on what assets you have. So you can transfer real estate into the trust. This trust can own your real estate interests that are held by LLCs or limited partnerships. And then when you do that, all of your assets, number one, avoid probate, and then number two, are distributed according to the terms of that trust. And so the nice thing about having a revocable trust in place is that you're naming a trustee that is going to administer the trust outside of court. And so that could be an individual trustee, it could be a corporate trustee like a bank or a registered trust company. But then you're making sure that all of those assets, no matter what state they're in, if they are titled in that trust, avoid probate. And then you can set forth the terms of distribution to the beneficiaries, how you want assets distributed. And so you're in more control of what happens to those assets, and all of that is done outside of probate. So that's what we recommend most of the time. And like I said, definitely to real estate investors. And then along with that setup, you still have a will. In that case, it's what's called a pour over will, where it's naming the trust as the only beneficiary in the will. Just a backup to the trust, that if you have an asset that is not named in the trust, has to go through probate, that it ends up in that revocable trust through probate. And then you definitely want to have, as part of your core planning, documents that make sure you're covered during your incapacity. So that's typically financial power of attorney. Sometimes you'll see it like Texas, it's statutory durable power of attorney, but basically who's managing finances for you. It could either be effective if you're incapacitated only, it could be effective now, but basically make sure that you have somebody named who can make financial decisions. Also have somebody named who can make medical decisions through medical power of attorney. And then along with that medical power of attorney, or healthcare power of attorney, whatever it's called in that particular state, then you'll have a living will, sometimes called an advance directive, and then a HIPAA authorization, which is who can get a hold of medical records if you're incapacitated or pass away. For the purpose of this call, like the most important one of those would be the financial power of attorney. So who's going to manage those assets that you have, or real estate assets, if you're incapacitated. So those are the core documents, really. So that's one area, is just your core estate planning. What happens if you pass away? What happens if you're incapacitated? Who manages everything for you? The second area I'll just lump under the term advanced planning. So that could be looking at how do we maximize your current estate tax exemption to pass as much as possible to beneficiaries tax-free. Something that we're talking to clients a lot about now is the current estate tax exemption in 2024 is $13.61 million per person. So you can pass the beneficiaries, if you're single, $13.61 million to your beneficiaries. If you're married, double that. You can pass that to beneficiaries tax-free. So over $27 million. And then, but what's going to happen at this point, maybe, is that that exemption is going to go up a little bit again in 2025, and then it is set to sunset on December 31st, 2025. And when it sunsets, it's going to go back down to, I believe it was 5.65 million plus inflation over that period of time, over the last it'd be 7 or 8 years. So it's really going to be probably closer to $7 million, I think, at this point, is what it would be when that sunset happens. So with advanced planning, something that you can do is look at taking advantage of the current $13.61 million exemption and looking at moving that out of your estate through certain vehicles like irrevocable trust, spousal lifetime access trust, stuff we can get into. But generally, the idea is that if you move 13.61 million out of your estate, and then that exemption goes down to 7 million, then you just have an exemption left of $0, right? If you move, so the idea is to take advantage of that additional 6.61 or whatever it ends up being exemption that you have available now to move outside of your estate. So if you move outside of your estate now, $5 million, and the exemption goes down to 7 at the end of next year, then you're just left with a $2 million exemption. You didn't necessarily do much to move anything out of your estate. So when we're looking at that, we're really looking at clients who have that ability to move a substantial amount out of their estate. So that's one part of it, is maximizing that available estate tax exemption. Another part might be, you have these real estate holdings. At some point, you're looking to sell those. And you might be looking at ways to minimize capital gains or spread those out. And if you're charitably inclined, there's trusts that are available, like a charitable remainder trust. If you ultimately would want assets going to charity, where in something like that, you can move assets into it, take an income stream for your lifetime or the lifetime of you and your spouse, spread out your capital gains taxes over that period of time. And then at the end of the day, those assets go to charity. And so you also get a charitable deduction, which can reduce income taxes, et cetera. So that might be part of that, charitable planning. There's other charitable planning options available, but that might be something we look at. And then it might be something like you want to gift assets to your kids. You want to start moving assets out of your estate. And so that's going to be something we would just call like a gifting trust if you're wanting to move smaller amounts out of your estate annually, which is a good planning tool for a lot of our clients. Up to maybe you want to make one large lump sum gift for the benefit of your kids, for example. That might be through something called an intentionally defective grantor trust, which is a way to move assets out of your estate and protect those assets for your kids. So we can get into more of those, but that's really what falls under that advanced planning, is more charitable planning using irrevocable trusts for protection of assets or for capital gains tax deferral or that state tax deferral. And then really the third part would be looking at any type of asset protection plan. So whether it's something as simple as putting real estate into LLCs or limited partnerships, a structure like that, all the way to preparing what we'd call a domestic asset protection trust, which are very particular to certain states. So we have a trust company with creative planning that's located in Nevada. So we use a Nevada domestic asset protection trust. But that's really that third area. So we're looking at core estate planning, advanced planning, and then, to a certain smaller extent, asset protection planning where it makes sense.
Yeah, that's fantastic, Lee. Thanks so much for giving us sort of the background and story here. I think for a lot of our listeners, they kind of want to simply understand where this comes in the process. So, for example, we do a lot of multifamily. We're general partners on these deals. We have a lot of folks that invest as limited partners as well. So let's say, they've been working for about, let's call it 10 to 20 years. They make an LP investment January 2025. And in 2026, they're thinking about estate planning. So now there's multiple ways that you can hold a LP investment too. You can hold it in your personal name. You can create an LLC and hold it in that. Or if you're a group, you can also create a limited partnership. After that point, and after you've already made the investment, you kind of already own the investment. What next? What happens next
Mm-hmm.
with an estate plan, and how is it, really protecting not only the investor but also the beneficiaries of this if in case they
Mm-hmm.
pass
Yeah. So it, for any asset you own, that first step, if you don't have an estate plan in place, would be to look at setting up that revocable trust, because that revocable trust can then own the limited partnership interest or the LLC interest or the general partnership interest, whatever it is. It can own real estate directly. It does not provide any protection. So with a revocable trust, the purpose of the revocable trust is to avoid probate and distribute assets to beneficiaries, whether that's spouse, kids, but it does not provide you any creditor protections. That's kind of a common misconception. Just because it has the word trust in it does not mean that it provides protection. And the reason why is because when you set up a revocable trust, you're what's called the grantor, which means you are setting up the trust and moving assets in the trust. You're the trustee, so you're still managing all of your own assets, and you're the beneficiary of that trust. So you're still managing everything for your own benefit. So there is no creditor protection there. It also uses your social security number for a tax ID, so there's no change in tax filing, tax rate, etc. The purpose of that is to avoid probate, and then that asset protection comes more in how you leave assets to beneficiaries. So the way that it would protect your beneficiaries is, number one, it avoids that probate process, and then it also you're determining distribution. So how do you want assets split among your beneficiaries, and then how do we distribute those assets to beneficiaries? So if it's something where you're distributing it to them outright, meaning they just get the share and can do whatever they want to with it, then there's no ongoing protection for them. What we recommend to most all of our clients is they actually look at holding whatever they're leaving to beneficiaries in a trust. So we can refer to this as a testamentary trust, even though that's not really the technical legal term, but it's testamentary in that it only comes into effect if you were to pass away. And so when you pass away, your revocable trust becomes irrevocable at that point, no longer be changed. And so each of your kids, like let's say you have 3 kids, you can leave assets to them in trust, and they can receive distributions from the trust at the discretion of the trustee. You name a trustee. That trustee could be the kids. They could be their own trustees. You might have a corporate trustee managing it, depending on their age and their financial acumen. Just really depends on your situation. But generally, there's a trustee then that manages those irrevocable trusts for the benefit of those beneficiaries. And then anything that you leave to them is then protected. So protected from creditors, protected from a spouse in the event they were to get a divorce, protected from them wasting it, and also making sure that those assets are managed appropriately for the kids or for the spouse or for whoever the beneficiary is, right? So that is really the first step. The other thing it does is that, let's say you title your real estate investments into this trust, it also does cover incapacity as well, in that if you are incapacity, you have a successor trustee that can manage those investments for you during your incapacity. So really that first step is to look at your core plan and make sure that you have that buttoned up, which is what happens if you were to pass away. Because you're building wealth. Like we said, you can either let the state choose what happens for you. You can go through probate or you can avoid probate. And then at the end of the day, we just want to make sure we're protecting those beneficiaries appropriately and making sure that wealth is protected that you're leaving to them.
Yeah, makes total sense. And thanks for explaining. Kind of moving over to one point that you touched on earlier, which is really minimizing taxes. And as real estate investors, our ears perk up every time we hear that. Can you just briefly talk to our audience about, giving assets away prior to death versus giving assets away post death and that stepped up basis? Can you just explain that a little bit?
Right.
And how an estate
Yes.
plan kind of comes to help that out as well?
Absolutely. Yeah. So if you the general rule is if you gift an asset to a beneficiary during your lifetime, they inherit that basis. And so you buy a piece of property for $1 million and it's worth 2 million and your basis is $1 million. When you transfer that asset during lifetime to the beneficiary, they inherit that $1 million basis. So if they go to sell the property, they're going to pay capital gains taxes, regardless of whether it's in a trust or owned by them outright. They inherit the basis. So that is one downside of transferring an asset that might have a low basis to a beneficiary during lifetime. Whereas upon passing, the asset gets a step up in basis. So one of the things you have to look at is what's more beneficial, whether you're moving an asset out of your estate for estate tax planning, or whether it's better to move that asset out upon your passing, basically just distribute it upon your passing to get that step up in basis. And then also, if you're married and you're in a state like Texas, it's a community property state. Anything that's community property, when one of you passes away, the entire estate gets a step up in basis. And then when the second spouse passes away, you get a step up again if it's planned correctly. There's certain situations where that might not apply, but if it's planned to get that second step up, then you would get the second step up. So that can substantially decrease capital gains taxes. And with the current very high exemption amount of over $27 million as you're planning today, most clients that we're working with, we're looking more at getting those step ups, if you will, versus moving assets out of their estate now, or where that step up or where that basis would be inherited by the beneficiary. That's one thing, is to look at the step up in basis, and you're kind of balancing what's the estate tax potential versus what's the capital gains tax potential that would be paid when you're looking at any type of planning with real estate. And so that definitely minimizes the number of clients that are really looking to transfer real estate out of their estate now. And I guess from an estate tax standpoint, or just let's just say a income tax standpoint, there's really not any other income tax benefit that you're going to gain from trust. So when we're talking about tax, we're really just looking more at estate tax minimization versus any type of income tax. So I guess with the step up, that's one issue. And if you do move assets out of your estate, what we're looking at is we want to generally move out something that has a basis that's closer in line with the current fair market value. And then when you move that asset out of the estate, they do inherit the basis. But if that asset is going to grow substantially, or that portfolio is going to grow substantially, then you might be leaving more out of your estate for beneficiaries than you put in. And so it really does come down to that balance of capital gains taxes versus estate taxes.
Yeah, got it. And that's such a unique plan, because in the multifamily space, also for a lot of our investors that invest in single family themselves, a lot of them are looking at 1031 exchanges to roll over the investment into new properties. And I think this combo of 1031 and a proper estate plan and, having, uh, you know, Texas is unique in the sense that it has community property, not all states do. But getting it
Mhm.
set up, even if one spouse passes away, is a huge benefit. And then if both spouses pass away and your kids are inheriting it, get it stepped up again. That's a huge benefit in terms of rolling that over and building wealth over a long period of time. Um,
Mhm.
if folks kind of do the math where you're selling a property and let's say paying about 20 to 30% in taxes every 5 years of selling that property and having all of those accumulated taxes actually roll over for 30, 40 years when your kids get it, that's a
Mhm.
massive, massive savings and generational wealth growth that you can kind of pass along to your kids if it's set up right, which is the main point of
Mhm.
even having this conversation today. It has to be set up right. Um, I think one issue is people don't know where to start. So apart from reaching out to you after this call, what do people do to kind of learn more about this? Where do they start?
Well, I mean, I definitely think that it really starts with talking to somebody, because there is a lot of information out there that you'll find that is potentially not applicable to your situation. And so it also depends on your goal, right? So I think a charitable remainder trust is a great tool, but it's only a great tool for somebody who has the goals accomplished by that charitable remainder trust and they want to leave assets to a charity at the end of the day. And so a lot of it is really knowing what your goals are, and then talking to an attorney to really go through what the goals are, what you want to accomplish, to make sure that that is in line with something that you can accomplish, or maybe that gets refined a little bit, and then work with them on what the best tools are to do that. Starting with the tools can be very dangerous. And so there is now we have a lot of information out there on what certain things are. But we do have a lot of clients who will come to us and say, hey, I read about this, or I heard about this, or somebody did this. And then I'm listening to them talk, and what they're telling me they want is not in line at all with what they just told me. So, um, like, for example, a high net worth client might come to me and say, hey, I was talking to somebody at the country club that said they set up this intentionally defective grantor trust for their kids, and that they did these things to move assets outside of their estate to their kids. And it sounds like that's a good idea. But then in a previous call with them, we restricted the amount that their kids were getting to not a nominal amount, but it is actually restricted in what they're getting. Like, they're not getting a third of the estate, they're getting a flat dollar amount. And so those two things do not coincide, because you've already told me you only want the kids to get this amount, but then under this setup that you're talking about, they would actually get a whole lot more, and they get it now. And then you have these negative potential, um, cons to it, like you lose that step up basis, et cetera. So it really is important to talk to somebody. So rather than starting with the tools, a lot of the time, it's more starting with your goals. What do you really want to accomplish? And what are the best ways to accomplish that?
Yeah, got it, Lee. Makes sense. For some of our investors, it's also a time consuming question of how long does this take? If I have three rental properties, for example, and I own all of them in my personal name, how long does it take to go from speaking with someone like you to actually having a revocable trust to actually having these assets in the revocable trust?
Mm-hmm. Yeah, we really work on about a 2 week time frame. So if we can meet with a client and talk through everything that they need and a situation like that, which is potentially fairly straightforward, a lot of times that's a 2 week process really to get your core estate plan in place. It's going to be have a call to discuss the plan, how you want assets distributed, who serves in roles like trustee and your power of attorney agents, and get everything drafted, and then follow up with another call to go through all the documents. And that would also include preparing deeds for properties. We can get the deeds, or we have the deeds, and then also preparing maybe business assignments for LLC interests. And we typically, at creative planning, we are I would say, very efficient. We're very good at what we do. We do a high volume of plans. And we have 42 attorneys that are part of creative planning legal. And we do, like I said, we work all over the country. But we try to make that process as painless as possible and as efficient as possible for clients. And so a lot of the times we'll try to get that core estate planning done within that 2-week period and focus on that. And then if there is anything that's advanced planning beyond that, there may be some additional follow-up, and that takes a little bit longer. Those typically require a little more discussion, a little more thought, because they are irrevocable, and once you set it up, it really cannot be undone. So we really have to think through those things. But for something like irrevocable trust, it really is just get it in place, right? Get something in place, because if you don't have anything in place, then you don't have anything in place. At least if you have a revocable trust, that can be amended over time. So if circumstances change, that can be changed, but it is important just to get that process started, just to make sure you have the foundational documents in place.
Yeah.
So really, I will say this, it should not be as painful of a process as sometimes made out to be. It can be fairly efficient depending on who you're working with.
Yeah. So one of the items that you had mentioned is the asset protection plan. So, you create your core plan in 2 weeks. That's all well and good. Now you own 3 assets in 3 different states. Is there a application per state that you have to kind of file for each one of these assets to kind of, have either the revocable or the irrevocable trust on the deed?
Well, so like if the property is owned by an LLC, for example, or limited partnership, then it's just assigning that LLC interest to the revocable trust. That's not filed anywhere. It's just an assignment. It may require approval. Like if you have LLCs where you have investors investing in that LLC, it may require a manager approval, like your approval, for example, on that assignment, but it's not filed anywhere. For a deed, like if you own the property individually, then it's just a deed where we're transferring the deed from you or you and your spouse or whoever to your revocable trust, which is filed in the county where that property is located. But that should really just be part of that core estate planning process.
Yep, got it. And in terms of that core estate planning process, you mentioned you can kind of set up one route where those assets sort of keep paying your beneficiaries, and you drop the timeline for it. Have you seen examples of also sort of the estate plan saying, hey, once I pass away, I want you to sell everything and then distribute all the sale proceeds to kind of the beneficiaries' kids, whatever?
You can do something like that. I don't typically recommend that. So when you're looking at drafting your estate plan, the estate plan should be specific in how you want assets distributed to your kids, but there should still be a lot left at the discretion of the trustee. So I'll give you an example. So one time I was working with an estate where, generally speaking, the parents specifically left a business to one of the kids, a condo in Florida to one of the kids, and then an offsetting amount in a bank account to one of the kids, and then they passed away. The business no longer existed. The condo had been hit by a hurricane and did not have any insurance on it. And the bank account still had some money, but not that same amount. So the only kid that walked away with anything really was the one that got something in a bank account. One got nothing, one got a defunct piece of property in Florida. When you're too specific and you're not taking into account everything that could happen, that, and you're locking a trustee into doing something, that is where you can run into problems in the future with litigation of your estate. So in what you're talking about, if you mandate that a trustee liquidate everything to then make distributions to your beneficiaries, that might not at that time be the best thing for those beneficiaries, especially if it's like 2008.
Mm-hmm.
That's not a good time to sell off everything that you've accumulated. So you can't predict what's going to happen. And so for the most part, when it's not just thinking about what is going into this plan, because you can write most anything you want into your plan. It's also looking at the administration of the plan at a future date. What does that look like when that estate is administered? And so you want to give a lot of discretion to your trustee to take into account those issues. So it might be language that you include that says it's your wish and desire that these things happen, but not necessarily direction. So you don't necessarily want to lock a trustee into having to do something that's in the document that may at that time not be in the best interest of your estate, in the best interest of your beneficiaries. It's not what you intended, but that's what the circumstances are at that time. So we use what we call precatory language, like I said, I wish and desire that my trustee do this. I don't typically recommend it just be liquidated. Your trustee, if you have an estate that's heavy in real estate, the other thing that I don't really recommend is specifying assets that go to each beneficiary. For that story that I talked about at the beginning of this, is that can change. You might not own that asset. That asset may have been subject to a 1031 exchange and it's now a different property. Might have an issue with it. It might be under litigation. And there's all kinds of things that can happen, right? So to a certain extent, as much as possible, we don't necessarily want to direct specific assets that could end up creating an unequal distribution if at the end of the day you meant for things to generally be equal, just because that's what can result in litigation of your estate. So we're not just looking at avoiding probate, distributing assets. We also want to make sure we avoid as much as possible any litigation of your estate that's just going to eat up assets unnecessarily. So a lot of it should just be more of a broad, I want my estate distributed in these percentages to these beneficiaries, and then here's how we're going to hold those assets in trust for them. And then pretty much everything else is at the discretion of your trustee. And so naming that trustee becomes a very important part of the estate. So who that is depends on your situation, whether you want that to be another family member, a business partner that you trust, one of the kids maybe, but then you might run into an issue where you don't really want one of your kids managing the trust shares for the other siblings. That doesn't go well a lot of the times. But so that is a very important piece to look at, is who is ultimately going to be the trustee and who do you want managing or administering everything for your kids, and then also managing everything for your kids or other beneficiaries. So with all that said, just when you're setting up a plan, don't necessarily want to lock a trustee into something that might have an unintended outcome, is really the bottom line there.
Yeah. So one of the questions, we've gotten, and we're not planners either, but a lot of the folks that invest today have assets abroad too. And so in this scenario, in which they own a house in India, for example, and they own multiple properties here, they have kids here and they have kids in India. That's a question, right? It's a very specific problem. The kids in the US don't really want to interact that much with the portfolio in India. The kids in India don't want to interact that much with the US. It's just like a little bit of a jumble mash. So, at that point, like maybe do you assign, all assets in country X are managed by X, Y, and Z, and all property in country Y?
Well, I think even simpler than that, like if it's India, for example, you're going to have an estate plan in the United States that covers your US-based assets, and then you're going to have a plan in India that covers those assets, and they're actually not going to interact with each other at all.
Got it.
or there may be some crossover, but from a tax standpoint or just an overall reporting standpoint. But from administration of the estate, anything like we can help with the United States portion. Anything that's foreign planning that might, or in a situation like that, would actually be done in India.
Yeah.
Where there could be crossover is you might have, and it depends on where it's located and what the country's laws are related to this, but let's say you own a beach property somewhere. It might be possible that that property is owned by a U.S. based LLC. That U.S. So then that might be integrated somewhat. If the property can be owned by a U.S. based LLC, there's still some foreign jurisdictional issues you have to work through. So it's also good to talk to an attorney in that country. You know, we deal with that a lot in a Caribbean island country where they own a beach house and maybe that can be owned by a US based LLC, or maybe it's that house is owned by an LLC in that country, which is then owned by an LLC in the US, and then that can be brought into the plan. So it is very situational or very dependent on which country it is, the nature of the property. And then also, like you said, what is the goal? Like if you have distribution of United States assets that is one way and distribution of asset in a foreign country that's another way, then maybe you're just going to have two separate administration or probate processes for your estate, depending on the country.
Got it. And so I think throughout this conversation, we've touched upon a few of the mistakes that you've seen, people make during their estate planning, coming to you and sort of giving you the plan without actually going through their specific scenario. What are some of the other common mistakes for folks to learn from before they start planning?
Definitely. I think, one of the big mistakes that we see would be the use of online forms or even like a LegalZoom or trustandwill.com, or to those you can really run into issues there. So, I've seen a situation in the past where somebody used a Susie Orman form, which is like, it used to be back in the day, like $39 for this trust package. And they, in that Susie Orman form, it's governed under California law. And it says that any asset that you transfer into the trust becomes community property. And so somebody, I didn't work with them, so they transferred money into this trust that they inherited. They actually transferred oil and gas interests into this trust, and they were inherited. That would have been their separate property. They transferred it into this trust, converted it under the language of the trust to community property, and then his spouse filed for divorce, and she took half of it when that all would have been his. So, those online forms are inexpensive, sometimes quick, but can have very negative outcomes if you don't know exactly what they say and how it relates to your situation. So that's something that we see. Like, I know, you'll see attorneys say, like, don't use these online forms because they want you to work with them. But I have truly seen these things go very south. The other issue that we see a lot of the times is we'll have people that come to us or clients come to us and they'll have a plan that has been put in place by an attorney. And then they have gone through and either struck through their documents, like struck through something, initialed it, whether it's their trust or their will, or they've added a codicil to their will when it really should have been an amendment to their trust, or they've taken something and they've done something that has been caused a problem, right? So if you have a plan in place and you need to make changes, it's important that those changes be done right. So like if you have a revocable trust, that's done through an amendment to your trust, and it's a formal amendment. It's not just crossing stuff out and initialing it. It's a formal amendment that updates your trust. You're not going to change distribution of your trust through your will, right? So those can cause issues, and that ends up, those are things that create that will create estate litigation, like we talked about. So trust litigation and estate litigation attorneys make a whole lot of money off of stuff like that, where someone has gone through and added in a codicil or added in an amendment, or they've written something out on their deathbed that they put on top of their trust, and it's wreaked all kinds of havoc. So, and that goes back some to what we talked about, not being too specific in things, to give discretion to a trustee, like ultimately outlining what you want to have happen, but not locking them into something that causes conflict or can result in litigation. So that's another thing, is really just inappropriate amendments or codicils to a trust. And then some of it does come down to like, let's say you've created a trust in one state. You lived in I don't know, Oklahoma, then you moved to Texas, right? The laws in Oklahoma, the laws in Texas, even though they back up to each other, are very different. And so if you're a high net worth client and you've got a plan that's drafted in Oklahoma that creates what's called a credit shelter trust when you pass away, and you have to fund that credit shelter trust with your estate, upon the passing of the second spouse, there's not that second step up in basis, is the bottom line, like we talked about. So if you've moved to Texas, even though you have a trust in place, or you've moved to any state, it is important to look at the laws of that state to make sure that your plan, given your situation, is set up in a way that takes into account those state laws. So you have other states, like if a lot of you are in Texas, there's other states, especially in New England, where you have state level estate taxes. Like Massachusetts only has a $2 million estate tax exemption that's non-portable. Well, if you move from Texas to Massachusetts, that Texas plan doesn't probably take into account that state level estate tax. And so if you don't plan for that, you're only going to get a $2 million exemption if you're married, and not a $4 million exemption. And that can be a difference of several $100,000 of estate taxes, depending on the size of your estate. So that, because it's not just what you're excluding from the estate, but also the marginal rate that's applied on how large your estate is that's over that exemption. So I mean, you could end up paying a lot more in estate taxes than you should, or your estate would pay a lot more in estate taxes than it should have. So when you move to a different state, it is important to take a look at it.
And Lee, for this point that you're mentioning, is it important where the estate plan was started, or does it matter where you sort of pass away, or you've lived for over 180 days, for example? Like if you set up the will and trust in Texas, but move to Oklahoma and pass away there after living there for 2 years, is that when this comes into play?
Well, yeah. So what I'm talking, it's where you end up, you're a resident where you pass away, right? So if you move to Oklahoma, you should really take a look at your plan and make sure that it is structured well for that state. So a lot of what we see is more a plan that comes from a non-community property state to a community property state, like Texas, where you can take advantage of some of those step up in basis rules that we talked about. Or Texas has a homestead exemption, for example. So you want to make sure that if you own your home in your trust, that your trust contains the homestead exemption, because counties are going back through and auditing trusts. You might actually get a letter at some point from a county that says, please provide us a copy of your trust that contains the homestead exemption so that we can verify that, for homestead exemption language. So, there's other things like that need to be updated. But you just want to take a look at it. If you do move your residency to a new state, that's really the time that you need to look at this, making sure that plan's updated.
Yeah, so
it is based on your state of residence or domicile.
Yeah, so that's another question I had for you. How frequent do you see folks revise their plan with you? It definitely seems like once you've settled into a new state, if you're moving, that definitely seems like a good time to do it. Are there any other times, that you see folks really circling around either big life events or so like that?
Yeah, big life events. I mean, of course, if you were to get a divorce or something, you're definitely going to want to update your entire plan. From a simple, from a basic standpoint, we recommend you just look at it about every 7 to 10 years. If there have been no substantial changes, we recommend that your powers of attorney be updated at least every 7 to 10 years. For example, and then that's a good time to look at the rest of the estate, just for if there have been any tax changes that might affect you, or rarely are there changes in state law that we really need to account for. It'd mainly be from a federal estate tax standpoint. Just make sure that still is drafted or set up appropriately for your situation as your estate grows.
Yeah, that makes sense. And last question I had for you was really, how do you see folks actually include their kids in designing this process with you rather than, doing it and then telling their kids, hey, this is kind of how it is? Like, is there a forum?
Mm-hmm.
Is there a way that y'all create that, even the beneficiaries come there and give their input as to how they want this done?
So my personal view is that you don't involve your beneficiaries. Just because I've seen that go poorly so many times. Almost every call that I have where parents have their kids on the call, nothing happens because you have too many people with too many different opinions that don't really know everything that's going on, making statements. And so the way that I look at it as an attorney is, if we're working with a client, they're the client. So you're the parents, you're the owners of the property, you're our client, and our main ethical responsibility is to represent you and provide you with our recommendations, our opinions, give you options on what can be done in your situation. Once it's created, once this is what you want and how you want to leave assets to your kids, then you might want to involve them. I just am of the opinion that it does not work out great, just from my experience, to involve them from the beginning. It can potentially cause more harm than good if there's something that's discussed that ends up triggering like some disagreement between siblings or disagreement between parents and kids. There's just more that could go wrong. I think they can go right in that situation. So I generally would say it's your plan. You do what you think is best. This is how you want to pass assets to them. And it's not that we're trying to like intentionally exclude them, but this is how you're leaving assets to them. If it's something where like you want one of your kids to be the trustee, then maybe that's a conversation we need to have with them to make sure they're comfortable with that and they understand what the role is. But in the design of the plan, maybe not include them until it's actually completed and then it's in place. So it could be changed, it could be amended, but at that point, it's at least something in place that could be discussed.
Thanks, Lee. Well, I have 1,000 more questions for you, but really, really appreciate your time. So, like, super interesting. I think everyone should, set out some time to really think about this because you never really want to think about this, but this is one of those things that impacts the future in a very big way. And so, if investors, want to reach out to you, where can they find you? Where can they find creative planning?
Mm-hmm.
How do they go about that?
Yeah, the best way, really, I mean, you can find us anything you want to know about creative planning, just at creativeplanning.com. We also have creativeplanninglegal.com that'll direct you to our legal page and just give you some information or more information on what we do. If you want to reach out to me directly, the best way is really just through email, and it's my name, just lee.bailes@creativeplanning.com. And if you do want to set up time to talk through your situation or have a consultation, we can do that. And I can shoot you out a link just with my calendar availability to do that. But that is probably the best way to get a hold of me and start that conversation, would just be to shoot me an email.
Thanks, Lee. Well, I might be reaching out myself, so expect an email from
Sounds
me
good.
pretty soon.
Cool.
Well,
Thanks,
thank
man.
you so much, Lee. Have a great rest of your
Thank
week.
you.
Bye.